Good afternoon, everyone. This is Rules Subcommittee consideration of House Bills 142 and 143. As per the committee notice, this is a hearing only. There won't be any motions taken today. And I anticipate that we will have a substitute probably early next week that will incorporate changes that have already been contemplated and changes that may be contemplated as a result of the feedback that we get today, frankly. There is a witness list, which is a piece of paper and a pen on the witness table. If you'd like to be heard, we'd like to hear from you. I'm going to go ahead and reserve the right, if necessary, depending on the length of the witness list, to limit comments. We have a hard stop at 3:55 p.m. There's another meeting, and we will be stopping at 3:55 p.m. What I thought I'd do just initially is to, not in the context of running through the bill really, but to help a common understanding of how we're approaching this issue. It's a committee meeting like any other committee meeting. We're going to have a hearing, get feedback. We have a bill which I believe represents an excellent starting point, but let me be clear on behalf of myself and other members of the subcommittee that it's a starting point. The bill that has been introduced is not the bill that's going to ultimately make its way through the Rules Committee and through the House. The bill itself, and I'll start with 142, you have three main pieces. You've got the Ethics Commission piece, how I call it, restoring authority of the Ethics Commission that it had before. That's pretty self-explanatory. You have the gift ban piece, which I think folks are generally familiar with. And then, of course, there's the what I would call, and others have termed the, well, who actually is a lobbyist piece, the definition of a lobbyist that requires registration, and the requirements that, other legal requirements that go along with being a lobbyist. Let me make sure it's clear. The author has made it very clear that his intent is to not have a situation where individuals who are coming to the Capitol to exercise their right to free speech, their right to petition their government pursuant to the First Amendment, to have that be threatened or imperiled in any way, or to make that more difficult. If anything, our responsibility is to go ahead and to make that easier. So with regard to the bill that you have in front of you, I can tell you without any hesitation that as we move toward a substitute, there will be changes to the bill that will provide that individuals will not have their rights suppressed in any way. That individuals can come down here, express themselves to their legislators or any other legislator, whether in the House or the Senate, and not have to register as a lobbyist and not have to pay any fee that goes along with that, and not have any reporting requirements that go along with that. That is the intent. It's the intent that the author has made clear. It's the intent that I want to go ahead and make even clearer. Of course, we don't vote on intent. We vote on words on paper. And the substitute that will be presented by the subcommittee to the members of the subcommittee for their consideration early next week will include that particular change as well, as it relates to the issue of who is a lobbyist. House Bill 143 really has two pieces to it. One is the campaign finance piece as it relates to local and municipal officials. We want to strike a balance between making sure that we have transparency and disclosure as it relates to local officials on the local level. By the same token, we don't want to make it so administratively burdensome that we scare off good people from stepping up and serving in those local offices. Because those local offices, we can tell you, and I'm sure that you're aware as well, those are the toughest jobs in politics. City council person, local school board, county commission. We don't want to scare people off from serving in those capacities because of administrative burden. We want to strike a balance between who we want to strike a balance between the disclosure requirements that exist, that should exist, but not making it overly burdensome. That, again, that's striking a balance, and we intend to find that balance. The other piece of the campaign finance bill has to do with, the other major piece, it has to do with January disclosure. There's a provision in that bill that will mandate the disclosure of contributions between January 1 and the beginning of our session, which is the second Monday in January. And that disclosure would be more timely. It would be within a certain number of days of the beginning of the session. And that, again, is producing more transparency. One other point I want to make about the situation of who is a lobbyist. I hope I've made it very clear that what we're trying to do and what we will do is guarantee that an individual who comes down here to petition their government and speak to their representative on their own behalf does not have any impediment toward doing so, either bureaucratically, administratively, or with regard to a fee. Again, I hope I've made that excruciatingly clear. We do want to make sure, however, that individuals who are here on behalf of organizations who should be registered are registered. The situation we do not want to have occur is the following. I'll give you an example. In the last week or two, we had our annual Nurses Day. And if you were in the Capitol, there were what seemed like hundreds of people in white coats. Those are the nurses come in for their annual legislative day, just like as many other professions do as well. We don't want to have a situation where those individuals would have to register as lobbyists and pay a fee in order to be here. No, that is not the intent of the bill, and the substitute that gets presented to the subcommittee will reflect that. I wanted to just make sure, I wanted to use an example, a real-life example, so it would be very, very clear. However, if an individual is here on behalf of an organization, it is not unreasonable for there to be an expectation that that individual on behalf of an organization registers as a lobbyist. Not every lobbyist or lobbyist group in this Capitol represents a Fortune 500 company. I can think of an organization just off the top of my head, Healthy Mothers, Healthy Babies. They do God's work, let me tell you. They're a nonprofit, again, not a big corporation. They have to register, and they do. And so all we seek to ensure is that those individuals who are lobbying on behalf of organizations do, in fact, register. So I just wanted to make sure that that was very clear at the top and set the tone for what we think, what I believe, I can only speak for myself, is a very, very strong first attempt at reform. And it's a reform that comes in response, really, to the people who spoke with a very loud voice this past July on the primary ballots on both the Democratic and Republican ballot. And while we go through our legislative process, albeit imperfect, it is a responsive process, and that's what this is meant to be. And the legislative process we will eventually get to and reflect the response that we should give that preserves individual rights, if not expands them, but also has an enforcement mechanism so that the laws are obeyed by everyone who needs to, follow them. I hope that's clear. With that, before we turn it over to the public hearing portion, I will ask the Majority Leader, Larry O'Neill, who headed our House Ethics Working Group for the last several months, to please offer any comments that he may have, both specifically on the bills, if he'd like, or in general from a philosophical approach standpoint, and we'll go from there. Mr. Leader.
Thank you, Mr. Chairman. I draw the committee's attention to House Bill 142 and just a brief explanation on a section-by-section summary, so it's before the rest of the committee. Section 1 gives the Ethics Commission back the rulemaking authority that they used to have. Section 2 provides definitions that are relative to public officers' conduct and lobbyist disclosure by establishing a distinction between expenditures and lobbyist expenditures and broaden the definition of lobbyist. Section 3 amends lobbyist registration requirements by specifying who is not subject to registration provisions specifically, and I'll point the committee's attention to line 268 regardless of how this has been represented already in the public to the contrary, and as you said, words on the paper, the registration provisions of this code section shall not apply to any individual who expresses personal views on that individual's own behalf to any public officer. And it goes on from there. You'll find that on line 268 through 270. Section 4 adds a new code section which incorporates the language we adopted in this session in our House rules about if we do deal with lobbyists on Capitol Hill, they should be wearing their badges, and we have to be part of enforcing that. We are not permitted under our own rules to do so. Section 5 amends lobbyist disclosure report by broadening those who must report now under the new definition of who is a lobbyist and required by law to register. And Section 6 adds a provision that any complaint must state whether or not the complainant, he or she, is acting as an agent for another person or is filing the complaint on their own behalf. That's House Bill 142. 143 has several provisions dealing with basically unclogging the overwhelming workload for the commission, especially dealing with local government reporting. We have evidence that many local government officials, school board people, municipal governments, county commissioners, often never raise any money, often pay their own qualifying fee, and yet often get fined for not reporting because they're still required to file reports to say that they don't have to file a report, which is a little crazy, and we're trying to put thresholds on that make sense so that the voters and constituents are well informed as to both the conduct and the conduct of those dealing with local elected officials. But it certainly imposes what we in the committee deliberated to be a far more reasonable standard than we had before. In addition, and I think one of the best additions to our disclosure code is that we discovered, and after much study, that there's a period of time between January the 1st, especially in the first year of any session, to where there are significant fundraising efforts that go on prior to the first day of convening of a legislative session, and the general public will not know who gave what to members of the General Assembly in the first year, especially till sometime in July, well after the session is all over. This is an effort to continue to make our conduct code to be the most transparent of any that I know of as we compare to all other states in this regard. That's a very general overview on a section-by-section basis, Mr. Chairman, of the bill, and I'm anxious, like you are, to hear the public comment in today's meeting and move this very important matter forward. Thank you.
Thank you, Mr. Leader. I want to echo what you said about the January disclosure. I think the sooner people have that information, on a point-and-click basis, the better off everyone is. With that, Todd, would you mind handing me the witness list right there on the desk? Okay, we've got 13 people signed up. So what I'm going to ask, and if someone signs up, as is our tradition, well, it's our tradition anyway in the Judiciary Non-Civil Committee, is that if someone signs up, they're going to be heard. And this is not going to be any different. But what I will have to do, since we have a hard stop at 3:55, is to ask individuals if they would limit their comments to 5 minutes. That will allow at least a round of questions from members of the subcommittee, if there are any questions. There may be questions, there may not be. But we want to try to keep the wheels turning, but also make sure we hear from everybody who wants to be heard. Are there any other questions from members of the committee about process going forward? Seeing none. Let me call on Debbie Dooley, please. And Ms. Dooley, there's no microphone there. There is a microphone at the lectern. It is 5 minutes, so I hope that's not too much time to stand. And let me just, if you could position the microphone a little closer to you.
I've got a big mouth.
And I just want to make sure I've got the right microphone button. I do.
Anybody that knows me will tell you that. I do want to praise the House for tackling ethics reform. The people sent a very loud message on July 31st. But the provisions you added in this bill to actually prevent grassroots organizations on the left and right from coming here is way out of line. Prior to 2010, there were a lot of lobbyists that were very well connected, that represented a lot of groups like the Chamber, some of the other groups that had very wealthy, a lot of money for to pay lobbyists, very high profile. They really owned the dome. The people would come to them and ask for their support for legislation. And I mean, if they wanted something passed, for the most part, it would be passed. Beginning in 2010, groups, grassroots organizations on both the left and right experienced an awakening. They began to get involved. They began to come down to the legislature. And all of a sudden, these powerful lobbyist groups did not have the power they once did. People were no longer going to them asking to have legislation, to have their ring or stamp of approval on legislation. And there was a lot of resentment from that. But I will remind you, gentlemen, that the Capitol is the people's house, and we are your landlords. If you're here representing the people, we are you landlords, and how dare you tell us that you're not welcome and put a close sign on the people's house. That is unconscionable for you guys to do that. And as far as these grassroots organizations, I mean, everybody knows that this is retaliation. Everybody knows that a lot of these powerful lobbyist groups don't like the influence that grassroots organization on both the left and right have now. We, the people, began the process of taking our house back. And I find it amazing and very hypocritical that a lot of the elected officials that support this bill that would require volunteers of organizations that don't make money, that don't raise a lot of money, to register as a lobbyist. A lot of these same elected officials and representatives in the House, I can tell you, people come to me all the time, they're running for office, and they want my organization's help in that. They go to grassroots organizations throughout the state and ask for their help to winning elections, yet you want to charge us to come to our house and to lobby legislators when we don't have money or resources to do so. I understand about the changes that were made, but you know, even with your change, it would prevent a pastor of a church here representing his congregation from coming here lobbying for and against legislation. Garden clubs, homeowners association would be prevented. Sierra Club, a lot of their volunteers would be prevented. NAACP volunteers. You have volunteers, teachers. If they're here representing their teachers union or their school, that's an organization. And this is an attack on our First Amendment rights because we happen to be an organization or group, whether or not we have money or resources. Everyone knows what this bill, it's like Speaker Ralston and some of the powerful lobbyists are pushing this bill. It's retaliation because we pressed for tough ethics reform and we took our message to the people. And I am asking you to amend this. If you want to have the definition of a lobbyist, then you should exclude nonprofit organizations. You should exclude people that don't get paid or spend more than $1,000 to be up here. Because if you don't, you might as well have this sign on the people's house. Again, we're your landlords. This is our house. You work for us. Thank you.
Thank you, Ms. Dooley. Maybe I didn't make myself clear earlier, but as I stated, I thought really ad nauseum earlier, excruciatingly clear as I would term it. The intent of the bill and what the substitute will reflect is that the scenarios that were just described are exactly what we don't want to capture, are exactly what we don't want to infringe or impinge upon. And the substitute will reflect that. And I thought it was important to say that at the outset in order for there not to be misunderstanding about what the intent was and what the substitute, which I understand has to be reviewed and has to be looked at. Trust but verify. I understand. We understand. So, you know, while we certainly welcome the idea of having individuals express themselves, our hope is that that would not include histrionics and hopefully an appreciation of the fact that, you know, it is understood that we are not going to go ahead and have individuals, volunteers in such organizations coming down to express themselves get caught up in that type of registration. And I thought I made that clear before, but perhaps not. I'd ask future witnesses, if at all possible, if there are constructive suggestions about, if you would, to speak to the bill specifically. We certainly will hear whatever is said, but I think it'd just be more constructive to speak to the legislation, any specific changes that need to be made in the context of the comments that have already been made. That's all that we can ask.
And I apologize, but not 5 minutes ago I heard you say, unless I'm just totally misconstrued what you said, but you said if someone's here representing an organization. They're volunteers that represent organization. I've been up here, Kay Godwin, other people in this room come here, and it costs us to be here. We don't get paid one dime. We volunteer our services for the greater good. And a few minutes ago, did I hear you wrong? You didn't say if you're here individually. I heard you say individually, but you also said the organization. I mean, you made that specific and said, made it clear if you represent an organization, you'll have to register. So
Ms. Dooley, I appreciate your comments, and we're going to try to not have a personal dialogue. But at the end of the day, you're also, if you're representing an organization, you're also representing yourself. And I think our challenge and the wording of the substitute that comes forward this coming early next week is, how do you strike that balance? And that's what we're trying to do. How do you strike that balance? But I'd again, ask future witnesses if they could speak constructively to the bill. I think we'd all appreciate it. Let me ask Mr. Richard. I'm sorry, Gruder. Oh, I'm sorry. I apologize. Ms. Sheldon had a question. Oh, Mr. Ramsey.
Yeah, I don't know if the witness was willing to take questions. I just had a couple of. And yeah, our job as members of the subcommittee are to look at the bill and read the words on paper and try to kind of figure out the best way forward here. And I've got just a couple of questions. What is your objection to the I guess the expanded registration requirements here? Is it purely about the money that the volunteers would have to pay, or is it the registration process in general? And the reason I asked that, because you said, well, nonprofits should be exempted, and if we carved out nonprofits, I do a little bit of this in my other job. I organize corporations, small businesses. Theoretically, Wells Fargo could go out and set up a nonprofit. A retired CEO who's not getting paid could affiliate with that nonprofit. He could come down, and I just use that as an example because it's a big, massive bank if you carve out nonprofits. And they would skirt on the registration requirements. So I guess I'm trying to figure out the best way, or I guess the crux of your concern. Is it the money
Yes,
Okay.
it is the process and the money. I have great respect for Lynn Riley. I see she's here. And Donna, for you. You have a good reputation. For my friend on the end in this little pink tie, which I love.
My wife loves pink.
But, you know, the issue is that there's a lot. It's not just nonprofits. I mean, when you're talking about a Tea Party organization, a garden club, these people are not paid. No one's paid to lobby. I could see if I am paid, which I wish we had money so I could be a paid lobbyist, but I'm not. I would be glad if I were paid, but it costs us to be here. I mean, it costs parking. We have to pay. We're not reimbursed for that. So that, and plus it's the reporting and the process when we're not being paid to see you guys and what we think is for the common good.
Right, and I understand that, but the tricky part is if you did a blanket carve out for nonprofits.
Don't do nonprofits.
Well, let me finish. Even if you said people that aren't getting paid, I could see some that being fraught with loopholes. So you kind of see the challenge, because I think it's important if a person's here on behalf of an organization and they're lobbying on behalf of whatever that interest is, whether it's the Sierra Club or any or the groups that I don't know, the
Atlanta Tea Party,
right.
Georgia Tea Party
Right.
Patriots,
and every group in between. I think it's important that we know what interest you're representing as a legislator, and it's important for the public to know the people, what interest, the special interest that individual's representing. So if I hear you, I think it's the money, the cost burden it places on groups such as yours and you personally and others in coming to the Capitol and then paying that additional, I guess it's $300 in the bill is the burden that you're speaking to.
Now, it's not just that. It's our First Amendment rights. We are not paid. One suggestion would be, if you want a suggestion, is that if someone is being paid to lobby or has a financial interest in the bill that they're representing or coming on behalf of, then they should be required to lobby. That would
to register.
To register. That would get rid of some of the loopholes. Many people, Richard will come up next, none of us are paid. How many in this room come to the legislature on a regular basis to lobby? Raise your hand. How many get paid to do so?
Right, but my again, this is
it's not just the money; it's the whole process.
But what I'm
Ms.
getting
Dooley,
at,
if you would just allow him to respond.
Okay.
what I'm getting at is
Thank you so much.
is a legal question, and that I'm trying to figure out how the law is written would apply, and I'm just struggling with making sure that the public knows the individuals, what their special interests are, and me as a legislator knows what I always ask people that come to my office on behalf of Bill, who are you representing, and what's your interest in this, and it's important for us and the public. But I'm also wrestling with I see the loopholes, and I see with what you're suggesting. It's just going to require some more thought in the context of Mr. Golick's suggestion that we are going to be continuing to look at this, is how we strike that balance. I appreciate your testimony.
And I do.
I'm sorry, Mr. Lindsay. We have to keep moving, Ms.
Thank
Dooley.
you very much. Just to sort of build on that, Ms. Dooley, and the others in the audience, to sort of build on what the chairman said a moment ago. I authored the bill 2 years ago that tried to tighten up the definition of a lobbyist with the hope of making sure that we didn't capture folks like you to have to pay a registration fee. In the end, quite frankly, what we had happen was a lot of people played games with it in terms of folks who were down here doing what you and I would probably both consider to be clear lobbying, but they were playing games with the tightening of it. So what we did in in the first draft, and I want to emphasize the bill that was dropped was the first draft. We went ahead and brought it back out so that we would get rid of the folks who had tried to game the system, and I see a few people out here who did try to game the system to try to avoid being called a lobbyist. sort of bring everybody back in. And now we've got to try to deal with the heart of the issue that you've described. And I agree with you. Someone shouldn't have to, in order to exercise the First Amendment right, and the chairman's already expressed this, have to pay a fee. But we also got to make sure that we get everybody in so that the public has that transparency side, so they see who's down here doing lobbying work. And hopefully you will agree with me there. And so what we're trying to grope with, like you mentioned nonprofits, and I must admit, you're going through what we've been through before. We looked at nonprofits, and well, the problem is that there's an awful lot of folks who have a financial interest who would be, quote, technically considered a nonprofit. Big employer in my district, Piedmont Hospital, is a nonprofit. If they come down here, I think they ought to have to be a lobbyist. So we sort of went through that. Let me ask you this: is really the heart of the issue, in order to try to have a level playing field, trying to make sure that folks who are actually spending money down here to try to influence legislation, and we want to be able to capture those people so that they have to list their expenditures so that the people know. So is that really sort of where we should be heading, in your opinion?
Yes, I agree.
Okay.
And we would be glad to work with you guys. I mean, I know Ed. I know Lynn. I mean, we had a great time in Tampa. And I know most of you guys. We'll work with you on that. But if you had a monetary threshold, that would solve a lot of the issues.
I think in terms of what the problem is, we tried monetary thresholds and people gamed the system. So
call me. We'll work with you guys.
That's what we're asking for.
You got it.
You give us some language, and I think perhaps you and I have sort of talked about this, sort of focusing in terms of people who actually have to pay a fee, as opposed to, if you're down here lobbying for a group, perhaps you should have to get a badge, but you shouldn't be having to pay a fee.
Or pay registration,
yeah,
the reporting form.
Pay that registration cost if you're not down here spending money trying to advance for cause. But let's sort of focus, if we can, over the next few days over that expenditure issue. Thank you.
I will. I'll be glad to meet with you anytime. You just let me know, because we want to work with you on this.
Mr. Gruder, let me, before you begin, I'm sorry that I wasn't taking at my word earlier. Maybe others were taking it at their word. This is a legislative process, and when we say that there are going to be certain changes that occur, there are going to be certain changes that occur, or else we wouldn't say them out loud. So, what we prefer to do, again, is to be constructive, and would ask that we go forward in that light. Thank you.
My name is Richard Gruder. I'm the founder of Preserve Our Constitution, Inc., a 501c3, although today I'm just here representing my own opinions. I have read your bill. Okay? I've read your bill, and I heard what you said earlier about not wanting to shut down individuals. But your bill does say, and you also said, if I were coming down here representing a group of 15 or 20 of us in West Cobb that were concerned about our government, study our government, founding values, things like that, which we're going to try to set up a group like that, I would have to come down here under your bill if I represented our group and pay the $330 and go through all the bureaucracy of reports and things like that. I don't think that's right, because that impacts on, I believe, not the First Amendment so much, but the rights of the people under the Georgia Constitution. I'm going to touch on that. It was Thomas Jefferson that said a Bill of Rights is what the people are entitled to against every government, and what no just government should refuse. Well, let me address Article 1, Section 1 of the Georgia Constitution, the rights of the people. Paragraph 5, freedom of speech in the press guaranteed. No law shall be passed to curtail or restrain the freedom of speech or the press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that liberty. The Supreme Court has said, and you know, that the right to tax is the power to tax is the power to destroy. And when you start putting money and bureaucracy and things like that in place, you're going to destroy the very thing you need, which is, number one, trust. And quite frankly, I've been involved politically some years ago for 15 years at every level in the state, even going to the Coverdell Leadership Institute training. So I know what goes on. I have a tremendous respect for each one of you up here, because I know what it takes for you to get there, and I appreciate you for that. But you know, you will address as many as 3,000 bills in a year, maybe 2,000 dropped in the hopper, 1,000 left over. If you sit there and read every one for 15 minutes, you'll only get through half of them if that's all you do for the 40 days, not going to committee meeting or anything else. You need citizen lobbyists to touch on those things that maybe you haven't thought about, so there will be no unintended consequences. And I think that's really important. So when you put these barriers, bureaucratic barriers up, and as far as the nonprofits are concerned, it seems to me like an easy thing to include in the legislature, that if a bank or an organization that's in here for financial gain has a nonprofit to do their work, it's pretty obvious that they want to come to you and talk about their bank. And you can certainly put it in the law there that it's illegal to carve out a nonprofit to do the organization's will. That's pretty simple. You guys write laws. I think you'd know how to handle that. The second thing, paragraph 7, back to the Georgia Constitution. Citizens, protection of all. All citizens of the United States resident in this state are hereby declared citizens of this state, and it shall be the duty of the General Assembly to enact such laws as will protect them in the full enjoyment of their rights, privileges, and immunities due to such citizenship. It's the duty of the General Assembly to enact laws that protect our God-given rights, not interfere with them. And it appears to me that you're interfering with our rights in this case. Even, like you said, not the individuals, where the way it's written right now, I'm going to come down there and speak to my own representative. I try to speak to somebody else, they're not even allowed to speak to me, nor am I allowed to speak to them under the bill the way it's written. So we can only go by what words are down there. And what bothers me is that you would do that in the first place. Why in the first place would you deny me my rights or anybody else's rights in the first place? That impacts on my trust for you, and I have the greatest trust for the people at the state level. But you're affecting my trust. The next thing, paragraph 9, rights to assemble and petition. The people have the right to assemble peaceably for their common good and to apply by petition or remonstrance to those vested with the powers of government for redress of grievances. Let me tell you what remonstrance means. I had to look it up. It says a forceful argument in favor or against something, or the act of such in making such argument. A form of protest, usually in the form of a documented petition. We're allowed under the Georgia Constitution for remonstrance. It doesn't say unless you're representing a larger organization, you're getting paid for it or something like that. It just says people can do that. And so when you're trying to set it up where the average person can't come down, where they're representing their homeowners group or a group like we're trying to form in West Cobb, where we study our founding values and our Declaration of Independence and Constitution, and perhaps the Constitution of Georgia, which would include things like this, and we want to come down here and speak to you about something we have a concern about, you're going to make me register, pay $330, send another reports and forms, plus I got to spend an extra day out of my life to come down here and register. I don't think that's right, and quite frankly, I think it's unconstitutional according to the Georgia Constitution.
Thank you, Mr. Gruder, for your comments.
One last thing, if I may.
Your time has expired, but please go ahead.
All right.
No, it's all right. Go ahead.
Okay. I think it would be instructive for us to read the preamble to our Georgia Constitution. The federal Constitution preamble explains the nature, extent, and the application of the U.S. Constitution. This, I think, does the same thing. It says to perpetuate the principles of free government, ensure justice to all, preserve peace, promote the interest and happiness of the citizen and the family, and transmit to our posterity the enjoyment of liberty, which is impacted here. We, the people of Georgia, relying on the protection and guidance of Almighty God, do ordain and establish this Constitution. Don't mess with our God-given rights.
We won't. Thank you for your comments, Mr. Gruder. Let me call on Ms. Kay Godwin, Georgia Conservatives in Action. And if I could just gently remind of our discussion and conversation earlier that, you know, as this bill progresses, and I had hoped to set a tone, and we'll just keep on repeating it. I fully respect the ability of individuals to stand up there and to say whatever they want to say. It would be helpful to be constructive toward the bill in the context of the comments and the exchanges that were made earlier, that in no way are we going to go ahead and have legislation that will infringe on First Amendment rights. It's about words on, that's the intent. The authors expressed that publicly. and we're going to live into that in the context of our substitute. So
Okay.
just a statement.
My name is Kay Godwin, and I represent Georgia Conservatives in Action along with
Thank
Pat Tippett. And most of you know that you've probably never seen me testify, because that's not something that I ordinarily do. I'm a behind-the-scenes person. But when I first read this, it upset me so bad that I felt like I was going to have a heart attack, and I mean that literally. Because when you start talking about my First Amendment rights of freedom of speech, that is a fundamental foundational block that cannot be tampered with under any circumstances. Pat, to begin with, I think that this bill was started out completely wrong from day one. We contacted the speaker and several other people and told them we wanted to be a part of the process. We are not your enemy. We wanted to be part of the process in building this bill to be something we could all work with. We never heard a word. We have worked with the Senate through the summer. They contacted us when they had hearings, and we went to those hearings, and we give constructive criticism and had input in that. The governor, when he gave his State of the State, he said that one of the most important things we do is build trust in the people. All I have to go by, you say you're going to change this bill and that it's going to be amended, but I don't have a clue what that is. All I have is what's written right here before me. And on line 97, it says, any natural person who receives compensation or provides services pro bono publico for advocating a position or agenda for the purpose of influencing the decision-making of a public officer, which can be anybody from city council to county commissioner to school board to the legislature, and who is neither subject to nor expressly exempt from any other provision of this paragraph. What I would like to see is struck from where it says, or provide services pro bono publico. I would like to see those words struck. And the reason I would like to see them struck is that most of you know Pat and I have been coming up here for 24 years. And it's in my 24th year that I'm having to deal with this. We come up here, we have approximately 83,000 people that we email on a regular basis that we keep up and keep them up on what's happening up here at the Capitol. And they depend on us, so that is a service that we are giving to the people of Georgia. And we think it is a very important service. Today when I was talking to one of the legislators, he didn't have a clue this was even in the bill. According to the way this bill is written, I wouldn't have even been able to talk to him because he is not my representative. He was very thankful that I shared this with him. We give him a bill that was underlined, and y'all can tell my mouth is as dry as cotton and I can barely talk. But this important to me. Y'all, we can't do this. The other part, you said you wanted constructive criticism. The other part is on line 281.
Well, I think I said feedback, but if it can be criticism,
feedback.
that's fine too.
Whatever.
And it is a public forum, so.
But in those 24 years that Pat and I have been coming up here, we've never had compensation. The last 2 years, I've retired, and so we can come up here more regular. We're here. We felt like that it was a commitment of ours to the God Almighty to be up here and to stand in the gap. And so we rent an apartment. We have slept on blow-up mattresses in that apartment. We've eaten off of a card table. We've drug a couch up here. And we've shared food many times because we didn't even have the money to get up here. It cost me $120 a week in gas just to drive back and forth up here. And so we take this y'all need to put water up here. We take this very, very seriously. Line 289 where it says any person who appears before a public agency, which can be city council, county commission, school board, or governmental entity, committee, or hearing, including but not limited to a committee of the General Assembly, for the purpose of giving testimony, but only appears at the specific request of the government entity and clearly identifies himself or herself and the interested party for whose behalf they are testifying. To me, what that says is that I can't even come up here and testify unless I'm not going to be able to even finish, unless I'm asked to do so. And the second one from 287 down, I want that struck out. I want that but only stuff struck out.
I appreciate your bringing that up, and I should have mentioned that earlier. That portion having to do, that goes back to individual testimony. Somebody just coming into a committee here and they want to be heard. said to Mr. Ramsey earlier, if somebody wants to be heard, they're going to be heard. That's those two provisions with regard to committee testimony as well as the publication piece that's right below it. That will also be amended in the substitute. But please continue.
Oh, and the other part is just that we can't even give information unless it's requested, especially requested. And I want you guys to know, we're Republicans. We have worked hard for you guys. I mean, I have spent hours, day and night, working on behalf of candidates. And we love you. We want to be a part of the process. Like I said, we really tried to be part of the process. And I'm really urging you, don't shut us out. Let us be a part of what you're doing. Thank you.
I appreciate, Ms. Godwin, your feedback. That was constructive feedback. We understand where you're coming from and why, and your pointing to specific provisions is appreciated, and it's not lost on us. That's all I can say, subject to public review of the substitute, and we'll just go from there. But thank you for that, for your presentation. Mr. Ray Newman of the Georgia Baptist Convention.
Thank you so much, Mr. Chairman. I appreciate the opportunity to have a word with you in the subcommittee this afternoon. I am Ray Newman, and I am a paid lobbyist with the Georgia Baptist Convention, representing 3,600 churches, 1,400,000 members. And I want to say to you, Mr. Chairman, and to each who are on this subcommittee, I appreciate your transparency and honesty with us at the very beginning today when you said what you said about the fact that you're going to be amending this legislation as it is now. My concern, of course, as others have been, is that from time to time there are pastors of churches who come here with me and talk with their legislator, and they may be here for a half a day, they may be here for an entire day, but they've come representing their church, which is, of course, an organization. They might come just one time. But to be able to say to them they're going to have to register, that's a great concern for me and has been. And I applaud you, and I'm thankful that you've said that you're going to take that out. That's not going to be a part of it. When we come here representing the Georgia Baptist Convention and the churches of the convention, we're dealing with social and moral issues that many times have various opinions on either side. And sometimes they're very controversial. But we take those positions and we speak to you in the best way that we know how to do that. This is my 10th year representing the Georgia Baptist Convention here, and it's been a pleasure, but it's a challenge to be able to involve others when I go and speak to churches and encourage their members and their leadership to become active and involved on the local level, also on the state level. And if this bill is kept as it is, taking your word it's not going to be, thankfully, that would further hamper them coming and would hurt them very much. And so I just want to thank you for that. And I look forward to seeing the substitute that's going to be coming forward from this subcommittee. Thank you.
Thank you, Mr. Newman. What happens a lot of times with major reform legislation is that you start out with good intentions, the best of intentions, and then at some point in the legislative process, it's inevitable that the law of unintended consequences, and the key word is of course unintended consequences, kicks in. But that's why we have the long, elongated legislative process that we do. It's on an overnight process, and that's by design. And that's to ensure that we get the best possible work product, knowing full well that with any major reform, it's inevitable, whether it's tax, education, public safety, it's inevitable that you usually come back on a year-to-year basis afterwards to have to make little changes that, you think you thought of everything. You didn't. You have to come back and tweak it, here again and again. And this may be, the case. I think our challenge here is to make sure that we get it as right as humanly possible on the front end in order to lessen the possibility of having to do, quasi-major changes, as we go on. And that's what this process is about. Your points are very well taken. I think it does come under the category of unintended consequences, and I can assure you it'll be taken into account.
I agree.
I appreciate your approach and your tone.
I appreciate very much what you have said. I know many times in these 9 years before me, I have gone into legislation and looked at it, and I've gone to even those who've authored the bill, and they've said, "Oh, that's not what I intended to do." and so there have been some changes made. And I appreciate the fact that you're willing to look at that.
Yes, sir.
And look forward to it very much.
Thank
you.
No, I should be thanking you, and I will. Thank you.
Thank you.
Ms. Judy Kraft. Oh. I just violated my own rule. If you've got one of these things, if you could just put it on silent or vibrate, I'd appreciate it. We'd appreciate it. Thank you.
Hello, my name is Judy Kraft. I live in Gwinnett County, and I brought my bottle of water with me in case I start to choke. But I want to thank you. I know this is not an easy thing to tackle. I think maybe you were the victim of some poor judgment, and whoever wrote the bill without a little bit more input, or maybe it was done too hastily. But I do appreciate the chance to try to make suggestions, and I'll just tell you my own background. I've been coming to the Capitol since 1995, and I was a legislative aide for Senator Clint Day. I knew very little about the workings of the Capitol, but I did discover quickly about lobbyists, and I know that there are the lobbyists who are paid to come here, who have a bank account and their parking is paid for, and they have the ability to, to entertain you and have a long time to talk with you. And then there's another category of citizens like myself who just developed a passion for trying to work on things that are good for the state. And I guess when I introduce myself to someone, I introduce myself as a pro-family leader or a pro-family lobbyist. I know I'm working on issues that are important to me and my family. It may be that I work on three things. I might come up and I might have an education bill, something on immigration, and maybe something on gambling that I'm interested in. And so I do that, but I just, in helping you to identify who should wear a badge and whether it should cost anything, I don't mind wearing a badge. In fact, I could come in the door a lot easier. I don't mind having my name so people could know who I am, but I do mind having to pay the fee. I think that people who make their living from lobbying and have someone that pays their parking and their gasoline bills and things like that should register as lobbyists. But I think that people and organizations that come up here simply because they want to help you understand their point of view, and I know you have 3,000 and 4,000 bills to read, and you do depend on people to help you, to give you those viewpoints. So I guess that's just about all I would say is, just one thing that Mr. Chairman, you did say in the beginning that this bill would not keep anyone from talking to their own legislator or their own elected officials. But you didn't say, whether or not it would keep you from talking to all legislators.
If I didn't make that clear,
Okay.
You're exactly the person who we do not want to, gather up in a net like that from a registration standpoint, and know the final product that will come out will not have any prohibitions or limitations or infringements. Whether you're talking to your state representative, Mr. Smyrie, myself, Ms. Sheldon, whoever it may be, no.
Good.
No, that's exactly the thing to not do.
All right.
So,
I wouldn't expect that. Thank you.
thank you, ma'am. Ms. Virginia Galloway, Americans for Prosperity, Georgia.
Hi, good afternoon, and thank you, Mr. Chairman and committee, for giving us a chance to speak and making clear the changes that you had in mind. I'm going to start out, I'm a very positive person, and so I want to start out by applauding you for the work that you did to make it easier for our local elected officials to not have to make reports when they spend their own money on their own little campaign and get elected to the school board or whatever. I think that's awesome and a step in the right direction. So thank you for that. Now, this other bill. That's a different story a little bit, but I appreciate your intentions. Let me just start there. First of all, it includes all state boards, correct? State-appointed boards, correct?
I'm sorry, can you?
Does this bill include all the state-appointed boards? Like
Public
DDS
officers.
board?
Public
Does
officers.
that mean board
And
members?
I don't want to get a sidetrack conversation. This does go to the dialogue earlier with Representative Lindsay and Representative Ramsey toward the influencing of a public official, and the individual, an individual who serves on a board, commission, etc., is considered, I believe, a public officer under
Okay.
state law.
Okay, so I am a public officer. I'm on the DDS board. I was
Okay.
appointed by the House, actually, for that job. And so I guess I can't buy my own lunch anymore because I'm also a lobbyist. And this is very confusing.
My sense is that that's not really what would occur under
I'm
this.
sure it's not the intent of the bill, but
Well,
but
I think even in
let's be
effect, I
careful.
think even in factual effect, that would not be the case.
Well, let's be careful. And
yeah.
also, my coworker Joel, we buy each other Christmas presents, and he's a lobbyist and I'm a board member. He's pretty cheap, but I mean, we have a zero limit now. So, no, he's a good guy. But
Well,
anyway,
I think we've captured that for the record.
now. I'm not a spokesperson for DDS, but let me just say we do hear from, on the board, we hear from attorneys who come to represent their clients.
Sure.
They shouldn't have to be registered as lobbyists.
They are not. And under this
to do
bill, in that context, if you have an attorney representing a client in either civil litigation, a criminal matter, or an administrative proceeding, or anything of that administrative communication having to do with an attorney, with a state board, a state department, that's exempted out.
Good, okay. My
Yes,
next thing is we also have, DDS regulates driver training schools and things like that, and sometimes they come and speak on behalf of their business.
Sure.
And some of their leaders, would they have to be registered as
No, ma'am,
lobbyists?
that comes under administrative proceeding, whether they're
Okay.
representing themselves or an attorney represents them.
Okay, great. All right, good. Now I'll get on to my real subject, which is Americans for Prosperity,
Okay.
because that's my biggest concern with this entire bill. I do not mind being registered as a lobbyist because I'm paid as the state director of Americans for Prosperity. My main job is not lobbying, but even under the 10% rule, I didn't want to take advantage of that, of the good grace of that, and some weeks I'm down here much more than 10% of my hours, although I work a lot of hours outside of here too.
Thank you for erring on the side of disclosure.
And I would do that, and I would encourage others to do that who are paid. But my main concern, of course, is the definition of what a lobbyist is, and I appreciate the fact that you are already going to change some of that. But here's the problem that I have in my suggestion. When you say on their own behalf, well, often the folks that come with us, they are here because they're altruistic, and they may, for instance, last year, they were lobbying on behalf of charter schools. Not on behalf of themselves. They may not even have kids in school. There were also PTA moms lobbying on the other side against the charter school bill, but they were lobbying on behalf of the PTA. I certainly don't think they should have to be registered. So we need to be careful of that on behalf of, unless they're being paid. And so I think we really need to have a standard of being paid. Now,
You've hit it very well, because that gets into organization versus individual. The ability to define that in the King's English is a lot tougher than I think some people
I'm sure
may
it's
realize.
harder than it looks.
It is, but that's why we get paid the big money
Big
of
bucks.
$17,000 a year to go ahead and figure that out, and that's our commitment, frankly.
Okay, well, my concern is, and I wouldn't mind having a name tag or something for our lobbyists. It took me an hour and a half to get my badge, even after I had pre-registered, just because they're a little slow over there. But when I just went to pick it up, it didn't take me but a second to pay. They take your money real fast. But to actually get the badge produced and handed to me, I just sat over there and wasted an hour and a half of my life. And I talked to a lot of other lobbyists who did the same thing. Now, that's not the end of the world for me. But if I'm going to encourage my folks to come up here, who may be on behalf of a cause like charter schools or something like that, or they may be speaking on behalf of their business, on a particular issue, which I don't think we should limit either. That doesn't, I don't think, makes them a lobbyist. But I wouldn't mind if they had some sort of temporary name tag, lobbyist for a day. I don't know what you want to call it, but something to designate them that was easy to get. But I do have a great concern with, of course, if they would have to pay for that. I think that just would be wrong. But the other thing is the reporting requirements. We several of us years ago put together the Atlanta Tea Party. I was the only paid lobbyist among the group that put on that Tea Party. Well, we spent a lot of money on that thing, and we raised it from some people in your body, some of that money. It was about $20,000 to put that thing on. And so I think we just need to be, we spent money to generally broadly affect public policy. It wasn't any particular bill, but I'm just going to caution you to just be extremely careful. I know that your intention, what your intention is good. I appreciate that. But I remember the bill a year ago that Representative Lindsay alluded to when they went and asked the Ethics Board, how would you interpret this bill? And they weren't going to interpret your intent. They were going to interpret what it said. And so we want to be just so careful to
let me address that
because,
right. Again, you've hit an issue right on the head, and that is, and it, again, goes back to the dialogue we had before. While you may have a situation where it's on behalf of a group, and an individual comes down, they're part of a group, but it's a nonprofit. They have no monetary financial interest in it. By the same token, and this is where we have to strike the balance, that again it's a lot tougher than may meet the eye at the outset, is the fact that it is seeking to influence a public official, and that making exceptions, while some exceptions certainly make sense, the individual coming down at the committee hearing or providing a publication and speaking to their representative or some other representative, whoever it may be, we understand that. But then that's one thing. But then if you're part of a group, but you're coming down as an individual, going back to my Nurses Day example, obviously we don't want to compel those individuals.
Right.
It really comes down to the circumstances, and being able to split that and define that is exceedingly difficult, because it is still attempting to influence a public official, which is a right secured by the First Amendment, and we understand that. But what we also have to do is make sure that we're applying the law equally, as equally as we can within the realm of reason, and again, in English. So I appreciate your understanding of the struggle there. That's what we're trying to get to, and it's striking a balance like everything else, but your points are well taken. Mr. Ramsey.
You're the second or third person, Virginia, and this is kind of what I'm wrestling with here, that's suggested, well, let's just remove from the definition of lobbyists provide services bono, people that aren't compensated to do that. And what's so the definition of lobbyists is it's not just who has to put a badge on or pay a fee. Those are the people that are subject to reporting requirements. Exactly. That's why it's so important that we get that definition right. And if we miss somebody, that person's not going to be required to report any money they spend influencing legislation. They're not required to disclose that they are lobbyists. They're not required to disclose, again, expenditures that they're making on behalf of whatever special interest they're representing. And that's why I don't know how we can exempt people. It simply remove provide services pro bono. I think we maybe need to look at the fee and who we can waive the fee for, because making the fee doesn't necessarily give rise to the obligation to do this reporting. It's coming under the definition of lobbyist throughout the code. So I think you hit exactly on what I'm wrestling with. I don't think it's as simple as eliminating provide services, people that just aren't paid, because then people would start popping up and people and say, well, I'm not getting paid to do this. I'm not subject to reporting requirements. I can do whatever I want to do to influence legislation because I'm not getting compensated to do that. So I guess that's not really a question. It's more of a comment on you and others that have suggested, well, it's just that simple, because it's really not. And I'm trying to wrestle with it, and of course, any ideas we have from people that are testifying, I appreciate.
Mr. Hamilton.
Thank you, Mr. Chairman. Virginia, this is so redundant, but I remember last year I had a bill and came and spoke to your group that you had down here and asking for support of it and everything. And so you're exactly right. It really creates a dilemma on how we do this. I also can give you another example. You had nothing to do with it, but during a heated campaign this most recent election cycle, there was a candidate that based their campaign on opposing all special interest groups. That was kind of they were against all special interest groups. Well, I contacted the candidate when one day they sent out a press release announcing the support of this other special interest group. And it became very apparent that what it was, they were picking and choosing basically which special interest groups they liked and which ones they didn't like. And so it was just another example of we all represent special interest groups to some degree. To some degree, and again just reiterates the complexity and the difficulty of doing this. So, but anyway, I appreciate you and your organization and what you do, and know that we're going to try to find the right balance to make this right as best we can.
Well, thank you. I really appreciate that. And again, we don't want to make honest people into dishonest people because we make a law that's so constricting that it's impossible to follow. And we certainly don't want to discourage public discourse on issues that are important to all of us. And can I ask a real quick question? And that would be, so can you pay, so a lobbyist can no longer pay for your lunch under this bill, a paid lobbyist or registered lobbyist, whatever. But you can you pay for your lunch out of your campaign account?
Under current law, in I think in Chapter 5 of Chapter 2 or Chapter 5 of Title 21, you can use your campaign funds for an expenditure that relates to the running for office, the fulfillment of office, and the retention of office, if I'm quoting that correctly. I don't have it in front of me.
So in fact, a lobbyist
who
wanted to pay for your lunch could just pay into your campaign account, but not during session.
Yeah, I mean, there's no campaign contributions during the legislative session.
I understand that, but
Right.
I'm just saying they could do it before the session started or in that little period in January before you start, and then they would be buying your lunch, but just not exactly doing it that day.
Getting into the intentions of what people do and when
I'm just trying to figure it out.
And when they do it, campaign contributions are governed in a completely different, part of the code. What happens there? What happens there in terms of campaign contributions? That will happen or not happen. What an individual candidate does or doesn't do with those campaign funds is their business, provided it's in compliance with Title 21.
Of course. I'm just trying to figure it out.
Sure.
Thank you so much.
I think Mr. Hamilton had one more thing, and then Mr. Lindsay had something that we've got to get to the next witness.
It really was somewhat related to that, and we've jokingly said things like, none of us want to go to jail over drinking a cup of coffee.
Exactly.
And the point is we as elected officials have certainly concerns with the unintended consequences on the other side of that. So should we accidentally do something that someone could construe or could legitimately be a violation of this? And so it's a very difficult situation to determine. It really is.
Well, I would be happy. I will offer my help if any or advice. It's free. It doesn't cost you anything. But no, I'd be glad to work with you on helping to define, particularly in organizations like ours who have members, who like to come on a regular basis, and we like for them to. Thank you very much.
I think Mr. Lindsay had either a question or a comment.
Just a quick question, sort of follow up on what Representative Ramsey was discussing with you and what we discussed earlier, and I'd like your input on it as well.
Okay.
In terms of being concerned about folks trying to game the system, if we focused on compensation, rather than, would it be better in your mind if we focused on whether or not some a lobbyist was making expenditures in order to influence legislation, have those folks be the ones to have to actually pay the fee, as opposed to folks who are simply down here pro bono, not necessarily making expenditures, but simply just advocating through their words for a position. Perhaps have them register, but not have them have to pay a fee, because we certainly don't want to close off the First Amendment for folks who simply want to come down here and express their opinion.
I think that's very reasonable,
Yeah.
although I would note that when I hardly ever have an expenditure in that regard. I think I've had 2 in my 6 years, and that was almost accidental,
Yeah.
where I bought a meal or I did something. I went, oh, darn, you're an elected official. I better report that, even though it wasn't to influence legislation. I'm just very careful about, the letter of the law. So I think that would be good as long as I think that paid people need to file the reports. I think that unpaid people, if they're not spending any money, certainly would not need to file reports.
Because we don't, for the same reason we don't want to see the local officials clog the system for the Ethics Committee when they're not actually.
Right.
Because that's been part of the problem with the Ethics Commission, is that they've been overloaded with reports from people that don't actually have any expenditures or
that would
donations.
be me almost all the time. Yeah.
Thank
Yeah.
you. And I do
Awesome.
appreciate you leaning on the side of reporting rather than trying to figure out ways to skirt around the system.
I try to play
unlike
by
some
the
other people
rules.
who
That's
game
why
it.
I'm watching these rules. I don't make them
that.
too hard for me.
Thank you very much.
Thank you, Ms. Galloway. Marcy Rubinson with GMA.
Mr. Chairman, members of the committee, I'm Marcy Rubinson with the Georgia Municipal Association. Thank you very much for allowing me to speak before you today. Local elected officials do take ethics disclosure very seriously, and it's very important to us that the public has the information that it needs to make good decisions. We are extremely appreciative that the sponsor of the bill introduced the local filing back into the state law. We think it'll streamline the disclosure process and will benefit both candidates and citizens who wish to access information. Furthermore, it will relieve the processing burdens on the Ethics Commission by returning the filing of the campaign contribution disclosure reports to the local level. That being said, we would like to recommend that the committee also consider returning the personal financial disclosure reports to the local level because it will allow the commission to completely eliminate local candidates from the Ethics Commission database. They won't have to track PIN numbers and filing ID numbers for the local elected officials if that piece is also returned. In an additional attempt to clarify and streamline filing, we would like to suggest that the date for the personal financial disclosure in the non-election year and the filing date for the June 30th campaign contribution report be aligned. Right now, there's no grace period for the personal financial disclosure, and if there were a 5-day grace period also allowed for that, somebody could file both of their reports on July 2nd and not inadvertently be past the deadline. Finally,
But they've got 6 months to file that, don't they? I mean,
I completely understand why there is no grace period.
I'm sorry to interrupt, but I just...
No, just for ease of filing. There's
Okay.
there's no good reason that they didn't. They'll just sit down and do them both at the same time.
I apologize.
No, I get very frustrated when they don't file it on time because I've had 6 months, but it just becomes a 5-day window that creates some confusion. Finally, because of the state filing implemented a couple of years ago, we do have over 3,000 elected officials who have been fined by the Commission for failure to file or for confusion on filing. And I would like to suggest for your consideration an amnesty on the late fees that are currently outstanding. The vast majority of the reports that were not filed by local elected officials, specifically city officials, had no expenditures on them. And while they did not do the filings that they were supposed to do, $125 for a personal financial disclosure and for a campaign report is punitive for some of my city officials. Thank you.
It's been my experience, just by way of anecdotally, that I think there's and this is always a function of leadership, and Ms. LaBerge, Holly LaBerge at the State Ethics Commission. I think there's an era of common sense at the Commission. I know that there have been some glitches in the electronic system, that there have been some mistakes on them. What I have heard anecdotally is that all that individual has to do is go over there, show the appropriate paperwork, and it'll be fixed. Assuming that they've got the proof that they did what they're supposed to do when they were supposed to do it. And so I'd encourage your members to, take them up on that. I understand that not everybody's in Metro Atlanta, that it may take a little bit of doing, but it can be done, and I think there's a sense of responsiveness in that office now that maybe we hadn't seen in some years past. Again, a lot of that's personal experience, individual members, and it may vary, but I'd encourage you to encourage your members to give them a shot at and helping them straighten out any records that are mistakenly reported or if they show an inaccuracy on them.
I do appreciate Ms. LaBerge. She's been excellent to work with. She and her staff have been very open to both partnering with GMA on sharing information and working with elected officials. There are certain glitches, though, that she may not have the authority to waive. City officials would file their campaign contribution disclosure reports early because they knew they weren't going to have any. and the computer would spit out a confirmation of their filing, and she was unable, because of the rules of the commission or because of the way that their system works, to accept those confirmations. And that's just the process that they have, and I'm understanding of it. I'm just hoping we can get some relief for the folks who really were complying or thought they were complying with the law.
Yeah, we don't want to have a situation where you're getting punished for being compliant. No. Mr. Smyrie.
I need just a point of clarification on the personal financial disclosure form. Did you say try to come back locally, or just to eliminate those altogether? Which one?
Bring them back to the local level.
So they were on the public financial disclosure. They would report that back to the local election authority in the respective county.
Yes, sir. Ideally, both of the reports would be filed in the same location, just to cut out any confusion.
Okay. As a follow-up to that, what in your experience with all the local elected officials in the bill, we have I think it's $2,500. What's the norm for the locals back home as it relates to campaign disclosure and campaign finance when it does not have to be reported to the state? What number? Is that a pretty good fit?
I would suggest that that's a great fit. That will cover 80%, more, probably even more than 80% of my city officials.
Okay.
Ms. Abrams.
Thank you, Mr. Chairman. Just to clarify, and actually going back to the chairman's question, I know that there was some issue when we transitioned from paper filing to electronic filing, that there were also a number of local officials who simply filed paper filings, not realizing they had to transition to electronic. Would those be some of the ones you were seeking amnesty for?
There was a lot of confusion early on about whether or not people were still eligible to file on paper, and they are still allowed to file on paper, but they didn't send it in certified mail, and the commission was not going to accept any filings that were done through regular mail. So that led to some of the confusion, as well as just a general confusion about having to file in general.
Thank you.
Ms. Renner.
A follow-up question on the same line of thinking. Of the 3,000 elected officials that you're saying that have not filed what they were supposed to, do you have an approximate dollar amount of what they would possibly owe?
The commission acted back in April, and certainly Ms. LaBerge is probably better qualified to talk about this than I am, but to limit the fines to $125 for campaign reports and to $125 for a personal financial disclosure. So any form that was not submitted or submitted late between the passage of the original ethics bill and April 11th, 2012, were only on the hook for $250. However, since April 11th, that stay on the amount of the fine increasing, I don't believe has been extended. So there is significant penalty out there on elected officials. And for some of my folks who are older, retired, on Social Security, $125 or $250 is a lot of money.
Mm-hmm.
Thank you.
Ms. Rubinson, thank you.
Thank you.
Ann Williams with the Georgia Council on Aging. GMA.
Thank you for the opportunity to come and speak before you. I'm Ann Williams. I'm Legislative Chair for the Georgia Council on Aging. I have been with the Council now about 15 years, actively coming down to the legislature for about 10 years now. I'm an appointee by the Speaker of the House and have been for the past 15 years. Our concern with the council members themselves, since we are uncompensated, and we are legislatively mandated to advise, let me see if I can read this for you, serve an advisory capacity to the governor, the General Assembly, the board, the department, and all other state agencies in matters relating to the elderly. In particular, the council shall make recommendations concerning the establishment and maintenance of an adequate program for the elderly in Georgia, recommend standards for services for the elderly, aid the department and other state agencies in coordinating programs for the elderly, establish indices to determine the effectiveness of programs for the aged, ensure that regular, adequate, and accurate reports are submitted by the component parts of the aging programs to the Council itself, publish regular reports of the Council's activities and the adequacy of state programs for the aging, and establish liaison with area agency councils on aging. And this mandate here was OCGA 49-6-20. And our concern here is we don't see on page 4 of the bill under the lobbyist definitions, lines 97 through 100, where it would cover this particular kind of advocacy that we do. And it's not clear in there, and we're very concerned about that for our members. We are uncompensated. So.
And you are statutorily mandated.
Oh, yes. That's the statute. I gave you the number. Mm-hmm.
Thank you for making us aware.
Okay.
Can you read that statute one more time?
It's OCGA 49-6-20. Yep.
Ms. Williams. I had thought in my mind, we covered that, and I couldn't find it, and Mr. Riley came over and just whispered in my ear about that it seems to be that line 300 may go ahead and exempt.
Line 300?
Yes, ma'am.
Okay,
the elected public officers or appointed public officials performing the official duties of their public office. My assumption is that would cover the Georgia Council on Aging as public office as well. If that doesn't, it will.
Okay. Well,
but we think that does cover it. We'll check it.
Yeah. Well, we appointed by the governor,
right?
Lieutenant Governor, Speaker, and the Commissioner of DHS.
Right. And I believe it would come under the definition of public official.
Okay.
So that carve out that exemption would exist under line 300.
Very good.
Yes, ma'am.
All right. Thank you.
Thank you. Oh, thank you. Better safe than sorry.
Yes.
Let me call Melanie McNeil, State Long-Term Care Ombudsman's Office. I want to thank everyone for being respectful of the time. We really appreciate it.
Good afternoon, Mr. Chairman, members of the committee. I'm Melanie McNeil. I'm the State Long-Term Care Ombudsman. I'm fortunate to have the job to represent some of our most vulnerable citizens, those who live in long-term care facilities. The Federal Older Americans Act and state law require that the state ombudsman advocate on behalf of older adults in long-term care facilities with federal public policymakers and state public policymakers. So I am registered as a lobbyist. I have an advisory council they're not appointed by public officials, but we have an advisory council. It's nursing home residents, it's aging advocates, it's members of the Alzheimer's Association. In fact, Ann Williams, who just testified, is our council chair. I'm concerned that section of the bill that she mentioned to you, lines 97 through 100, would not cover those folks who we asked to come down and advocate on behalf of issues that affect residents in long-term care facilities. So case in point, just a few years back, you as a body agreed to increase the personal needs allowance for long-term care residents. We asked nursing home residents to come and talk with their elected officials as a part of what we do. So I'm concerned that they would not be covered, or that they would end up having to register. And part of the issue is the registration, going through that process and having to pay for it, but also part of it is the reporting. And then if you miss the reporting, then what you have to pay as a fine. So I would ask that you exempt advisory councils for state agencies, state offices, other governmental agencies, and quasi-governmental entities. So that would get it like the area agencies on aging. They're quasi-governmental, 10 of the 12. Think about Senior Week. I know you have all been here when we've had Senior Week with hundreds of older adults. You really don't want them to have to register, I don't think. So just making sure that, again, you're not doing what it is that you said in the beginning, that unintended consequence of requiring folks to register. But what I do really like in the bill is Section J, which is near the end, which says if you are a state employee, like I am, you don't have to report. Because I got caught in that situation. I was a few days late with a report. I was out doing some training for ombudsman and didn't realize until I got back to the office 3 days late I filed my report late, $250 fine. That's a lot for a state employee who hasn't had a raise in years and years. And, you know, what I got back from the commission initially was, well, just pay it out of your own pocket. Because I didn't want to pay it out of the program fees, of course. So I appealed, and I went before the board, and there was someone else who was also a state employee in my same position. You know, she just missed it by a few days, totally just oversight. She was also supposed to have to pay the $250. Well, they knocked it down to $25, so, yeah, state employee, I can pay the $25. But all that to say, there are a lot of us that, as you know, we don't take you out to lunch. We don't. My report is always no expenditure, no expenditure. So to be exempted is a great thing, and I hope you'll leave that.
Ms. McNeil, let me ask you a question. I know about the state ombudsman's office, and we understand that, and that exemption, I think, is pretty clear. You mentioned in your initial comment about the advisory
We
board.
have an advisory council.
Advisory council. How many people are we talking about?
12. We have 12 on the advisory. We have.
Okay.
It's our charter says we can have up to 20, but we have 12. And there are other, like the Aging and Disability Resource Connection. Those are also connected to the area agencies on aging. They have advisory councils. The same thing.
Are they engaged in government lobbying? I mean, do they come across the street and
there may be folks who are involved with those councils who are coming here, like during Senior Week, for example, to advocate on behalf of an aging issue,
right.
Access to services, access to information. I mean, I'm not sure.
The individuals, as relates to Senior Week, I think we've all stated that we're very conscious of that, and that's over here. I'm more concerned about the in-between nature of your advisory council itself. Does it rise the level of a board or a commission or
right.
or what? And I don't know what the answer to that is.
They're not appointed by public officials
Okay.
As the ombudsman. Of course, this was set up before I became the ombudsman, but we try to have a cross-section of folks, so people who are in facilities, other folks who have connection with them, so aging providers or aging advocates.
Okay.
And we might say to them, like we did when we were trying to increase the personal needs allowance for residents, please go over to the Capitol and help us advocate for this issue.
Okay. Do they serve a particular term of office, or is it just a...
Yes, it's 2 years.
Okay.
Each appointment is 2 years.
Okay. I see no questions. Thank you, Ms. McNeil.
Thank you.
Let me call Elizabeth Poitras with the League of Women Voters of Georgia.
Thank you, Mr. Chairman. Thank you, committee. Thank you for giving me the opportunity to speak. I really appreciate your opening remarks, Mr. Chairman,
Thank you.
for what we can, because I came with my guns loaded. As many people in this room, we were totally dissatisfied with what we saw in the original bill. I'm looking forward to what comes out of the next submission. I want to thank you for bringing this to the forefront. This is something that we have needed for a long time, ethics reform. And we are working hard to get it done. And I know you're working hard to get it done. And I appreciate you giving us the opportunity to give you feedback. First of all, I should have introduced what I do. I am the president of the League of Women Voters of Georgia, and it is a non-paid position, totally voluntary. Unfortunately, it's about 60 hours a week if I do it right, 40 hours if I sometimes do it. The League has a mission of educating citizens and teaching them and promoting and encouraging them to learn about their legislative process and to be participative in that. We do that by bringing folks to the Capitol. We encourage League members to come to the Capitol to speak to their legislators and all legislators. So again, it's necessary that organizations like mine and like the one that I have been involved in for so long have that opportunity to be a citizen. Just please keep that in mind. We have lobby days. Lobby days, we go visit people that are not in our constituency, but we want them to know what we're doing, what our legislative agenda is, and what we can do for them. We want to make ourselves a resource for them if they choose to have us as such. So I would ask you to take that into consideration in your new submission, and I'm looking forward to that. And I don't know what the timing will be, but we are really looking forward to seeing what that's going to be. One other thing on the other bill is the local filing. I agree with the local filing going back to the municipal taking. The one thing that bothers me about that is there's no transparency because it's only paper that you can get from that point. It won't be available, as I understand it, electronically.
It will be subject, I think it was beforehand, subject to open records, is my understanding, both then and now.
Okay.
An open records request.
Through the mail, paper copies.
Depending on where you are. I mean, generally
Okay.
where that's going to be is, an individual, a citizen of a city, let's say it's outside Metro Atlanta, will want to go in and see the disclosures of the local city council. They'd go into the local, whether it's housed in City Hall or if they have an elections board, or it depends on the city or county.
Sure.
They have a right, and rightly so, to that information.
But I'd like to see that moved to be not immediately, but so that it could be, the local municipalities could put that so that it could be viewed
Electronically. I mean, I think we all would prefer that. I would say, and that would be the case in large part in Metro Atlanta. My understanding is that there are a lot of jurisdictions outside that aren't there with regard to electronic ability. My sense is that it wouldn't be a difficult transition to get to that.
My sense too.
It's more a function of will than of ability, but it's something to keep in mind.
Okay. The other role I play is the League is a member of the Georgia Alliance for Ethics Reform, and I'm going to relent the rest of my time to the next person that's on the list because I think he's got a lot to say for our alliance, and I appreciate the time that you have given me, and I'd be glad to answer any question.
I don't see any. Thank you for taking the time to be here.
Thank you.
Terry Lawler of the Regional Business Coalition of Metro Atlanta is the next person on our list. Well, Ms. Poitras, you are at 4 minutes and 51 seconds. Oh, sure. I mean, Oh, okay. Mr. Perry, you're officially over time. Just kidding. You're on the. Mr. Perry's on the list, and we will certainly get to him. Mr. Lawler, are you here? Okay.
Yes, sir, Mr. Chairman. I am here. I'm Terry Lawler, and I'm the Executive Director of the Regional Business Coalition of Metropolitan Atlanta. It's an association of 14 chambers of commerce throughout the metropolitan Atlanta area. We represent tens of thousands of business and over 1 million employees. A number of you have actually been very actively involved through your local Chamber of Commerce in a number of roles, some of them related to the Regional Business Coalition. What I'm here today is to talk to you about how this would impact your local chamber, but also provide you with some suggested language that may address, Mr. Chairman and members, what you're trying to do in relating to people who are lobbying versus those who just come down here for a special day or whatever. I think every one of you who has been involved in your local chambers knows we all have a public policy committee that's made up of individuals from the community. In Fayette County, the chairman is from a cable company. In Gwinnett County, it's from a human resource company. I think in Cherokee, the chairman is from the Water Authority. And in DeKalb County, it's from a building contractor. People who don't come down here ever, except on the Chamber Day. But they may come down here on that Chamber Day and talk to you about specific legislation that Chamber of Commerce has adopted in their legislative agenda. And I noticed you had used the word agenda in here in issues that come before them. And again, as you all know, you meet with your Chambers of Commerce before the session. They do talk about their legislative agenda. That being said, in an effort to try to get at those 1 visits or those 2 visits for individuals who come down here, whether from Columbus or anywhere else, I would suggest that maybe an exemption language that talks about people who come down here who have incidental contact with no expectation of meeting with multiple public officials over an extended period of time may get to what you all are trying to do for people who just come down here for a day or 2 or 3 to talk about, but have no expectation of being here all 40 days. I think the thing we need to all remember about this, even though we've all been talking about the 40 days down here, we have to also remember this covers the other 316 more days throughout the rest of the year that this provision still takes place. And when that member from the cable company who happens to be chairman of the Government Affairs Committee meets you in Publix or Kroger, and they don't happen to be your specific legislator, they could fall afoul of this if they're not wearing a badge if they had to be registered. So I want to offer you on behalf of the local Chambers of Commerce, the individuals who are not registered, who do not come down here except once or twice a year, but you may see them back at home, that we'll be glad to work with you on language that gets at what you're trying to do, Mr. Chairman.
I really appreciate your saying that, and again, this is something I should have said earlier, is that as we moved, we've taken input from those who have offered constructive input. I would actively encourage you, if you have specific language, and obviously we have things that we've identified right away that we said at the very outset of the hearing. We get that. Nevertheless, if there is specific language that any group or individual would want to go ahead and submit just to make sure that we're aware of it, if we're not already, I would actively encourage that. From a process standpoint, it's our hope to have a fresh substitute early next week. Exactly when early next week, I don't know. It would then come out of the subcommittee, and then it would go to the Rules Committee. The Rules Committee as not as you would think of the Rules Committee. The Rules Committee as what I would call a non-procedural committee. It'll be in the full Rules Committee, just as a bill would be in the Judiciary Non-Civil Committee or in the Education Committee, and will be debated there as well. And so opportunities, if there are issues that arise, and they could arise between subcommittee and full committee, that possibility exists as well. And then it goes to the Rules Committee, the Rules Committee in its capacity as the doorkeeper to the floor of the House. So that's purposefully slow and deliberate, and again, that's by design. So I just wanted to make sure that process and procedural quasi-roadmap was out there for folks to know if they're interested. But we appreciate it, Mr. Lawler, as always. If you have specific questions, I think you may have a question. Mr. Hamilton, did you have a? No? Okay.
Thank you.
No questions. Thank you. Oh, Mr. Renner? I'm sorry.
Not for you, but for you, Mr. Chairman.
Yes, ma'am.
I actually was going to make a comment about the incidental contact over an extended period of time, and just wanted to, sometimes we file a bill, a bill's filed, and we have people that come down here as part of an organization that will follow the bill for a period of time. And when he said that made me think that incidental contact what exactly does incidental contact mean if you're looking at one particular bill, and I may be your representative, but they want to talk to everybody here. So that to me was extremely confusing when Mr. Lawley.
Yeah, I appreciate the question, and that goes right back to the conversation about the definition and getting a definition as tight as you can, knowing full well that you're not going to go ahead and get it 100% .00 tight, but you want to get it as close as you can. And to the extent that we can avoid amorphous or ambiguous terms that are just by their very nature ambiguous, we're going to strive to do that. I mean, the intent, obviously, for Mr. Lawler is good. But thank you for the comment. Terry Green.
Good afternoon. My name is Terry Green, and I live in Cherokee County. I wanted to speak to one particular thing that you mentioned in your opening statement, Mr. Chairman, and that was about the initial ballot questions that we voted on that came out of the state Republican Party in July. The ballot question for the lobby gift read as, do you support ending the current practice of unlimited gifts from lobbyists to state legislators by imposing a $100 cap on such gifts? I don't think that this was intended as a poll to see if a normal citizen like myself who comes down here on their own, I don't pay, nobody pays me to lobby for pro-family issues, but I don't think that this poll question was meant to punish the average citizen. I think it was trying to get a pulse of the people of Georgia who were in the Republican Party as to what they felt should be spent on legislators to lobby you for a particular bill, not punishing us as normal citizens for coming up here. Because I know that 4 years ago I came up here and went over to the Sloppy Floyd building, and I got a lobby badge, and I paid $25 for the process of that badge, and I had to report what I spent on myself every 3 months through email, which was zero, because I paid for my own gas, I paid for my own food. I never came and took anyone out to eat. All I did was lobby. Helped Georgia Right to Life. I was here last year for the fetal pain bill. Many of my friends were here. I supported Virginia in the charter school amendment. So I guess my question would be, I don't want people to be confused as to what this ballot question was about to begin with. It wasn't about everyday citizens getting the pulse of the Republican Party that we should be charged to come up here to lobby. Because I ask you, when you have a bill that you care about, an immigration bill like Matt Ramsey was a part of, and you had citizen lobbyists coming up here supporting you in that immigration bill, when you have a bill that you want to see passed that is good for the state of Georgia, you're going to prohibit many everyday average citizens who don't have a lot of money to come down here and help you to promote good government. So therefore we see this as a restriction on everyday people just coming up here to promote good government, like we did with Matt Ramsey, like we did with Georgia Right to Life in the fetal pain bill, as we did with charter schools, as we may do with the insurance exchanges. And how will that prohibit us? I mean, you will be prohibiting us to go forward and speak to those issues.
Just to make sure it's clear, we have two separate issues. One is the gift ban, and the other is the lobbyist registration and who is a lobbyist under our law, and our ability to define that in such a way that those who should be registered as lobbyists and report as such do, and those who are citizen activists like yourself who are simply coming down here to express themselves pursuant to their First Amendment right to speak to their elected representatives, whether it's your representative or some other representative or a senator or whoever, without having that infringed and without having to register as a lobbyist and not having to do the disclosure paperwork. I think we've hopefully made clear throughout the hearing, including comments from just about every member up here, that where we're going with the substitute version of the bill is exactly what you've expressed. The intent of the author and the author has expressed this on multiple occasions now publicly, but we want to go ahead and make sure it's reiterated and clear, crystal clear, that that's not what we intend to do, and that we'll be making changes in the bill to ensure that's not the case.
Well, I just wanted to, because I think in your opening statement you alluded to when the room was fairly full of people and it was standing room only, that this ballot question spoke to beyond what it really spoke to, and only spoke to what people were to give you to lobby, not restriction on everyday citizens. Because as I said, 4 years ago when I had my lobby badge and I went up there to get it, and the girl said, well, who are you? And I said, well, I'm Terry Green. And she said, well, who do you represent? And I said, myself. And she said, well, what do you want to put on here? And I said, well, my name. And she looked at me like, well, why won't you put? And I said, well, just put me, because that's who I'm representing. And I had to file every 3 months if I had to spend any money, and I didn't. And I didn't mind having the badge. At that point, I only paid $25 to have it made.
Ms. Green, let me just make sure it's, again, crystal clear. In anyone's opening comments, including my own in this hearing, there are two separate issues. The ballot question that occurred this past summer has nothing to do with the lobbyist issue. It has to do with the gift ban. Nothing more, nothing less.
But the poll was not, okay. But
that's all it has to do with is the gift ban portion of this legislation. The lobbyist and the who is a lobbyist issue is completely separate.
Okay. I'm sorry, because
No, not at all. Please don't be.
I thought I misunderstood you to give the impression that the people voted and spoke on, they only spoke on the ban on lobby gifts, not on the ban on everyday citizens being able to come up here.
Right. Well, there's no ban on everyday citizens. What there is, we're with a bill. We're working with a bill that's in process. Just to be, again, clear, the vote this past summer, both on the Democratic ballot and the Republican ballot, had to do with the gift ban, nothing else.
Well, what will we do when good bills come forward, and you need people like myself, Virginia, Pat, Kay, and Judy, and my other friends that come down here, and you need us to promote that bill for you, or get behind something that you're promoting that we see that is very good?
What we will do is we will ensure that there will be nothing that we pass out of this General Assembly which will infringe upon your ability to exercise your rights under the First Amendment to petition your government freely and openly without any limitation whatsoever. That's what we have to do, and that's the promise that we have to make and deliver on.
Well, okay. In closing, I would just like to ask you to consider, too, that when you go back and you're at a session and you're in your homes in your district, have you thought about that if this does go forward and I have to go and pay $325, and then you're in your local county and you're running and you need the help of your local people, your local Tea Party, maybe this would restrict the amount of work they would be willing to do on your campaign if they're restricted here to promote good government.
I don't know how many times I need to say this, so I'm going to say it one more time. And I'm just going to say this once.
I'm sorry, I didn't.
Not at all.
I'm not trying to be a joke.
No, not at all. All I can ask is, all any of us can ask, all the author can ask, is to simply be judged by the final work product that we produce out of this House. And that I would ask you to reserve judgment until you see that.
Okay.
Fair enough?
Yes, sir.
Thank you.
Thank you so much.
Where time has expired. Let me ask, final witness is William Perry with Common Cause of Georgia.
Thank you, Mr. Chairman and members of the committee.
And Mr. Perry, I'm going to hold you to the 5-minute rule as well.
I didn't have 509. I'm sure there's the expectation of a lot of criticism, so I want to start off with talking about what's good here, because this bill has some good in it. The first and foremost, the fact that this is happening, that there's a committee hearing and there's discussion on it, is a big step. For the last 3 years and leading up to today, there's been a lot of governing in the dark. And I think the products that have come out the last few years from governing in the dark have created a lot of problems, including the 10% rule. which we'll get to. So I'm glad finally that light is being shined on this process, and I appreciate you all for coming today and allowing for the discussion to happen. You're so close on limiting lobbyist gifts to legislators, so you should be applauded for that. You're close. There's some exceptions that are some pretty big problems, but you're at least making the step to get it close. Rulemaking, as it's worded, is great, and it needs to happen, and I know a lot of people have been begging for it. The disclosure of the campaign funds collected in January is a very good thing. No longer having to wait till July and non-election years to get there. From a personal standpoint, something I would never advocate be written into law, but the fact that UGA football games are exempted, I think, is a very good thing, because I think it should be almost a requirement of this body to attend those once a year at least, in order to make sure that you represent the state well. It's been said a lot that ethics was going to kind of quickly be dealt with and gotten through so that we can get back to the people's business. But I think the people have demonstrated by the turnout here and the number of speakers you have that this is pretty high on their agenda in terms of their business. I was mentioning the governing in the dark and the result of the 10% rule. There's been some talk about gamesmanship. And so I'll tell you, I gamed the system. I did that. And the reason I did that was because I felt the 10% rule came out of gamesmanship. That was created by a bill that was handed out to a committee, voted on and approved without anybody getting to see it first, and sent to the floor and voted on there. I gamed that system, not to try to get around it, but show what a problem that particular clause was, and had no intention of trying to skip over paying for a lobbying fee, but to show that a lot of people could still lobby and get away with it under that rule. So I'm glad it's eliminated. Some of the, and there's been also talk about the referendum. I think it was an extremely important measure because there was almost 400,000 more people voted for that limit on lobbyist gifts than voted in the highest total number of votes cast in the PSC race. So again, I think it ranks highly on the people's business of where this belongs. So I'm glad you are taking the time and giving this the sunlight it deserves. Again, loopholes in the cap. You wanted some specific things in the legislation that could change. Taking the exception all the way down to the subcommittee, I think, is extremely dangerous. Don't like that it gets down to the committee level. But I think we're safe where all the members of the General Assembly could be invited for something, and that it can cover those days so that Georgia cities and counties can come up here and advocate and hold their days as they do today with Chatham County Day and things like that. I think that's an important part of the process. I think putting in language such as official duties when it relates to travel and things like that is dangerous when you don't define what official duties are. The registration at events is also something that's undefined and could be clarified. So those could be reasonable exceptions, but because it's such a broad term, we have no idea where the limitations are on that. Again, the travel based on officials' duties, I think, is a problem. And one thing that was struck from the law that I think was a good measure, and since there is still the ability for a lobbyist to spend money and for a legislator to accept money, is the disclosure. And I think that taking away that $1,000 threshold on spending is something that should be restored in order to make sure that there's no gamesmanship in the system and that money is spent and isn't either disclosed or it doesn't trigger registration. The second bill that you mentioned, 143, that deals with the local filings, I think is also a good step in the right direction to lift the burden from both the commission and those elected officials at the local level all over the state that don't raise any money, I think is a good thing. I do think that sharing that load with the local filing officers is also a very good thing and something that we should restore. But I think the bad thing is that you might be throwing the baby out with the bathwater in terms of transparency, as it was touched on a little bit earlier. that if you send it back to the local levels and you leave it there, then it's a lot harder for people around the state to see what's going on in other parts of the state or even in their own counties and cities. If you leave a function or a requirement, say within 30 days, that the local filing officers make those documents appear online as the current system does, because we've already got a system that does that, then it can go a long way in helping with transparency. I know I don't want to make Marcy jump out of her seat, but I think a return to online filing by local officials, where you train the local filing officers to help somebody come in and use the computer and report online, would be great, because it would continue our transparency. It would relieve those that don't know how to use the computer or fear it to be able to go somewhere and still file online so that we could all see it very quickly. And then I think just kind of to address some of the questions earlier that was being asked about the fear of the registration process, and do people fear having to pay the registration fee. I think that's part of it, but I think a quite chilling effect on what could happen if there is such a broad definition, or even for small groups that are represented by people, is the opportunity to get fined. If there was an opportunity similar to the local level registration where you can say, I'm not going to raise any campaign money. If you can also say, I'm not going to spend any money on elected officials, sign an affidavit or swear that you are not going to do that, then giving people the opportunity to maybe register without having to fall under those fines, which can get as high as $10,000. I think that is more of a chilling effect than a $320 registration fee, even though that is a large chilling effect. So those are some areas of improvement. We'll be happy within the next week, even the next few days, to work on some language and return to you that are very specific to the general comments. And again, I thank you for your time.
Thank you for your comments. There are some questions. You know, I'm going to make one comment, then I'll give it over to Mr. Lindsay. You had said earlier that, you know, you gamed the system and you didn't do, obviously didn't comply with the law. You know, when you're just a little bit of advice.
Mr. Chair, I didn't say that I didn't not comply with the law. The law
Okay.
allowed a month look-back period.
Okay.
So I followed that. I didn't think I was going to get over 10%. The only reason I did was because we had issues here and at the city of Atlanta. Those combined took me to about 14%.
Well, you said openly a minute ago that you gamed the system. How did you game the system again?
Well, I was putting in quotes, game the system, because I was testing the 10%, the legal opportunity to check as to whether or not my 10% of my working hours went to lobbying. I mean, I guess maybe gaming the system isn't the right way to do it, to say it. But I had the legal ability under the ethics law to see if I would get to 10% before registering as a lobbyist. That's what I did. I followed the law.
Did you operate in good faith?
Absolutely. I tracked down to 15-minute increments how often I did work lobbying or on legislation versus all the other things that I do, including both here at the state capitol and at the city of Atlanta.
I would just submit to you, and I don't like to make things personal. I never have. I don't know you, but anyone who's going to stand in judgment of someone else really ought not to go ahead and proactively go out of their way to game the system in order to make a point. You could write an op-ed,
okay,
but don't game the system.
Well,
we all operate in good faith to a certain extent. That's the expectation, Mr. Lindsay.
Thank you, and let me sort of build on that a bit for a minute, Mr. Perry, and I appreciate your candor. I think that you were, quite frankly, telling exactly what you did when you first made the original statement. But that's not the only time that you tried to minimally follow the law, is it not? I mean, for instance, is the Georgia Alliance of Ethics Reform, is that a registered, is that a registered lobbyist as well, or organization lobbying here?
Each one has lobbyists representing organizations, but it's not an organization. It's an alliance of some registered, some not registered organizations. That's not trying to take advantage of the system at all.
You don't believe that organization, that umbrella organization, shouldn't have to register?
No, I don't.
Do you believe that we should require an umbrella organization overseeing other lobbying groups? If there's an umbrella organization, do you believe that we should conclude in the law a requirement that those kind of organizations also register? Do you believe that that would be important in terms of open and transparent government?
I think in terms of open and transparent government, I can only speak to the Alliance and what we do. Everything we do is open and transparent. We have registered lobbyists, and those of us that need to be registered are and do. Those of us that aren't required by law aren't registered as lobbyists and shouldn't have to.
Well, I'm asking a broader question now. Do you believe that an organization that purports to have some type of umbrella over several other organizations to try to come up with one common goal in terms of lobbying down here, do you believe that we should be including within the law a requirement that that organization register? I'm asking.
If there is somebody who is being compensated to lobby, they should, yes, register to lobby. If there's somebody involved in the organizations that's not paid and does not receive benefits, then no, they shouldn't have to register.
Okay, so an umbrella organization should not. I'm trying to get an answer to my question if I can. I'm asking a simple question: should an umbrella organization that is lobbying down here have to register in addition to the subparts that are part of that alliance? I'm just trying to figure out where we're going with the bill.
I think it would that simplifies it too much. You can't say yes or no. I think it has to get back to the individual being required to lobby. If you're receiving compensation for lobbying, you should have to register. If you don't, you should not. And I want to clarify, under our current system, in which you have to pay $320, file reports every 2 weeks, and possibly get fined up to $10,000.
Which gets to my next point regarding, we've talked earlier about the problem with other people gaming the system in different ways if we went toward paid versus unpaid lobbyists. And I really appreciated some of the comments that we heard earlier from other organizations under your umbrella that wanted to focus on expenditures. Would you agree that we ought to be focusing on the expenditures of that individual or the organization rather than on whether or not someone was paid or not paid? Wouldn't that be a better way to try to capture?
That would be another way to capture it, and the way that the current law does with the $1,000 trigger, I think, helps that, and that should be looked at, absolutely.
Would it not be better to go ahead and just drop that down to zero rather than $1,000?
That's food for thought.
Yeah. Getting back to the Alliance and its operation, who paid for the bus tour?
The bus tour was actually not something that involved the Georgia Alliance for Ethics Reform.
Yeah.
The bus tour was three groups.
Yeah.
Common Cause Georgia, Georgia Conservatives in Action, and the Georgia Tea Party Patriots.
Okay. Did y'all list that as an expenditure?
Those organizations filed a a ballot committee and worked as a ballot committee and collected money and disclosed all expenses and contributions.
Oh, good. So that was included. I'm just trying to
Yes, sir.
trying to make sure that we're being as transparent as possible.
We are.
Have you guys always reported every expenditure that you have in terms of lobbying?
As far as I know, yes, sir.
Yeah. Y'all did, however, file one about 6 months late, correct?
File one 6 months late? No, sir.
A disclosure.
No, sir.
Didn't you, according to, I saw one AJC article that indicated that y'all failed to divulge the fact that y'all spent money on dinners for legislators last summer.
Okay. We amended a report. Yes, sir. After taking a look at the law, realizing we made a mistake and went back and corrected it. Yes, sir.
About 6 months late.
I'm not sure of the timing, but I'll take your word for it.
Okay. Did y'all pay a fine?
No, sir, because we did, in good faith, file a report, and we amended that report once we figured out that maybe we ought to go back and do so.
Should lobbyist organizations such as y'all that file something so late be able to amend reports 6 months late? Let's just say, take for instance, if oil company A failed to file a expenditure report during the session and filed it instead 6 months later, would you expect them to be fined?
I think that with
it's a simple yes or no.
Okay, can you repeat the question?
If let's just say hypothetical oil company A spent money during the General Assembly session on a legislator and then waited 6 months before filing a report on that, should they be fined?
I know you want a yes or no question, but again, I mean, things aren't that black and white. They're a little gray. Did that oil company forget to file a couple of $100 worth of dinners? Should they be fined? Probably not. If they made a mistake and they corrected it, I don't think anybody wants to see somebody fined for realizing there was a mistake and correcting it. Now, if they chose not to file a report for 6 months that involved thousands of dollars, maybe even, whatever amount that was in some way deliberately withheld, then yeah, they should get fined. And thankfully in this legislation, you're looking to give rulemaking authority back to the commission so that everything doesn't have to be that black and white, that there actually can be some gray areas that are determined by using common sense as opposed to just the letter of the law that was written in the dark.
Okay.
Mr. Ramsey.
Thank you, Mr. Chairman. Just I guess more of a and I think Mr. Lindsay, after I wrote this question down, may have touched on it, but just to be clear, I think I wrote this down when you said it. You said if you're not receiving compensation, you should not have to register as a lobbyist. If you're not receiving compensation to lobby.
Or if you're not benefiting from legislation.
If you're not personally benefiting from legislation.
Well, I can give you an example.
Well, I mean, I'd really, rather than an example, how do you define benefiting from legislation?
I'd love to sit down and talk about that because I know our time is limited, and so it's not, again, a simple answer. But if you would meet with us, we would be glad to sit down and hash that out. Or put further thought, and we'll put it down in writing and give it to you.
Well, of course, I'm sure everybody would love to have your thoughts, and I think all of our email addresses are publicly available. I think I may have received emails from you in the past. But I think you touched on kind of the crux of this, and I think something needs to be said here that may have been lost throughout the course of this, and you made the comment, and others have made the comment about this process occurring in the dark. I think it bears saying, I want to say thank you to the ethics working group and the product they've put forward today. We've spent 90% of our time talking about what the definition of a lobbyist is, and it's a critical definition because that is the linchpin of who has to report their expenditures and who doesn't. You would agree with that, right?
Yes.
I mean, we've got to get that right because
Absolutely.
If it's too narrow, people that want to game the system like you did, not with nefarious motives purportedly, but people that you prove that it can be gamed, they skate from having to report making expenditures on any of us up here. So you would agree that the definition of lobbyist is absolutely fundamental to the integrity of our entire system here.
Yes, absolutely.
So, and I think the sense has been, well, maybe we erred on the side of capturing too many people in this first draft, or maybe we erred on the side of too many people being required to pay the fee in the first draft. I think that's the side we need to err on, given the fact in the first draft, recognizing, I think you've heard an earnestness from all the members, including the chairman from the outset, that we're going to take a look at these provisions as they go forward and get it right. But the definition of lobbyist is just fundamental to this whole process. And if we leave loopholes, people are going to game the system, and they're not going to have to report their expenditures on legislators. And we're right back where we started. So that's why that's why the definition of lobbyist has to be a part of this. But what hasn't been said is this is the first public hearing this year on a real bill, a proposal that's going to be law, not the change in the Senate rules that they put forward that literally is so fraught with loopholes and possible abuses, it really doesn't even pass the laugh test. They haven't put it forward in a legislative hearing where folks like y'all can go in and talk about it. That's the legislative process, and that's why we're here. This is not being submitted, this version on paper being submitted to the governor today for signature. So I just want to thank the authors of the bill, that presented the bill, Mr. Lindsay, who's on the bill, Mr. Smyrie, who's on the bill, for putting forth a very, very, very aggressive measure that will fundamentally change the manner and the amount of which money can be spent on public officials. And to the extent that we need to work on making sure we don't cast too wide of a net to impact First Amendment rights, I think the chairman said it from the outset. We're going to do that. I'm committed to that, and believe me, you've got a bunch of hardworking folks sitting up here that are going to do that. And in concert with any comments that y'all send, we're going to consider them. So thank you, Mr. O'Neill, for presenting this bill, and thank you to the members of the Ethics Working Group for putting forward this excellent first step a real reform, and Mr. Chairman for conducting an excellent hearing today and giving the public an opportunity to participate.
Thank you, Mrs. Sheldon.
Thank you. I just really have a comment about the process myself. Definitely want to applaud the author of the bill and the working committee. All these, this is our first meeting that's open to the public. We definitely are here for comments. Nothing is being voted out today. We're going to continue to work on this bill. It's important that we hear from our citizens. I think we heard from you guys when we got the bill, the concern about the citizens, the PTA moms or the nurses or different individuals coming up. That is not our desire at all. We call ourselves proudly members of the People's House, and as we're here to represent you guys. So I look forward to addressing that issue. But I think the thing that's been kind of interesting is it seems to have been lost in a lot of the discussion of the day and the testimony. Even one of the Terry Green discussed the amendment this session, or the referendum this session, the questionnaire, the ballot question. And a majority of citizens said they wanted a $100 cap. Well, the House and the author of this legislation knows that there are many loopholes within a cap and took it even a step farther. And I think he definitely needs to be applauded for that. And look forward to working with this group and hearing from you guys as we address the problems in this bill.
Mr. Smyrie.
I just want to say to you, Mr. Chairman, and members of the committee, I've been working with the leader for the last few months, and this is my 39th year in the House. And I've been through a lot of ethics legislation per se, and I've talked to a lot of public persons as it relates to the bill, and I'm glad that your comments early on left it open end that this is everybody knows the legislative process. This is our first thing out to shoot, and I just want to thank everybody that came and come in earnest discussion and dialogue at a public hearing. I for one believe in transparency in government and being above board in all that we do. But having gone through ethics legislation in 39 years it's a moving goalpost, so to speak. After you kick this field goal, you'll be kicking another one 6 or 8 years from now. But at the same time,
and you'll be here.
And
I hope you will.
I won't be here. But at the same time, I think having discussed it with a lot of people that have testified at this hearing, I'm very open-minded about this process and about this legislation. And you don't stay in office for 39 years not listening to the public. And that's my responsibility. I take it seriously. And but I wanted to take this opportunity to thank the chairman of the subcommittee, Representative Golick, and having worked with members of the working committee for the last a couple of months or so. I think this starts the process of serious dialogue as to how we do business here at the state capitol. So I'm looking forward to continuing that dialogue.
Thank you. Mr. O'Neill.
I really am still struggling mightily with the definition of a lobbyist, and I've looked at wherever that's manifested itself in 49 other states. I know the organization you represent is also resident in several of the other states. I would personally very much appreciate if there is a suggested definition of a lobbyist, given that we both agree that that's the cornerstone of any ethical reform, true reform rather than gimmick, as to who that might be. If you all could help with that, I would personally love to hear from you, or frankly any other members of the audience, rather than just say we don't like what you have. Tell us what you think it ought to be, without maybe just my little group being cut out. I mean, what it ought to be for all the people of Georgia, and address the issues that obviously these people on the ballot felt like that we as elected officials are unduly influenced by lobbyist activities. So who's a lobbyist is very important to regaining the trust of those 9 million people out there that deserve to be able to trust their own government, and we intend to make sure they can better than they ever have. And any help you or others can be in that regard would be very much appreciated by this one member of this committee. And you know where my office is, and you know how to find me or call me, and as soon as you know, I'd really appreciate it.
Yes, sir.
Thank you,
We'll
Mr.
get to work on
Chairman.
that.
Thank the Majority Leader for his comments. We'll wind up just by reviewing a very brief history of time.
Mr. Chairman, there were some comments directed my way. Could I address those before we close out?
We only have a few minutes.
I'll
You
be,
could
I'll
take a
be
minute. You could take a
very
minute.
brief.
Sure.
Because I think that, first of all, mistakes can happen in a process. Mistakes can happen in these ethics laws, and I think that no one blames anybody or faults anybody for making a mistake. But those things are easy to fix by governing in the open, as we've talked about. The gamesmanship doesn't have to happen if we have more discussions like this. It was mentioned the rule versus the cap. I would contest that there are more loopholes in this ban versus the $100 cap that happened in the Senate. And I would like to have that discussion, and I'd love to have it publicly if we can. And I'll close out by just saying this, that there were some pointed questions today. I'm glad to answer them the best I can when I can. I may make a mistake with them, but if I do, I'll always come back and admit it, and I'm always glad to talk further about it. So I hope that there's just not the gamesmanship of trying to get somebody to say something so we can say, aha, gotcha. But we can continue the dialogue on both sides so that we can make sure that we come up with the best public policy possible. Thank you.
Mr. Perry, I'll respond to that and then close this meeting. I mean, we're citizen legislators. We don't have this is not Congress where you have dozens of staff doing this to people. Look at the hand. No, we're as accessible as air. So if anyone wants to talk to us about anything, all they need to do, I can only speak for myself, is pick up a phone or an email. And or send an email, it comes right to me. There's no filter. There's no staff look at it. It comes right to me. So, to this minute from your organization and from, one or two others that may scream the loudest, I haven't had a direct communication. I'm very easy to work with. I've spent 14 years gathering that reputation, credible or not. So all I can do, all any of us can do, is be available to those who want to be constructive in their comments and offer real suggestions for improvements, because this is law, and this is a point I wanted to make that I want to just end, and it's really a point that Chairman Smyrie made. We started this really with the summer ballot. And if we've learned nothing else, we know that we have to lead by example. And the leader of this body, the author of this bill, listened. He saw, he listened, he learned, and then you lead. And these two bills are an example of that. It is a first step. It is the only measure that I have seen to this minute in the General Assembly that has been introduced that has the force of law and provides the mechanism for enforcement of that law. Anything else is inadequate. Let's just be kind. Inadequate is kind. That's where we are. This is a process. We look forward to working with whoever wants to give us constructive feedback and input toward tailoring a very measured, well thought out, tightly defined law that we can be proud of. Why? Because to not do that would not be responsive, and that's our first responsibility, as Chairman Smyrie said, and that is to be responsive. We'll end with that. I appreciate your time, members. Thank you. You'll receive a notice on this is important. Hold on. You'll receive a notice on the subcommittee meeting. We will endeavor to put a substitute out as soon as we humanly can. At some point early next week, we will endeavor to have a meeting notice go out 24 hours in advance. We will endeavor to have that substitute out as soon as we can, hopefully in conjunction with that meeting notice. We'll get it as close as we can, but there will be an opportunity to review both the members and public. Let me just remind one thing. This is the first step. It goes to the Rules Committee and the Rules Committee's Substantive Committee of Jurisdiction role. And then it goes to the Rules, and then it's still in the Rules Committee in its role as doorkeeper to the House floor. So let's just keep that in mind. And then it goes to the floor, and then Lord knows what they're going to do after that. So we'll go from there. Thank you.